Welcome to the deep dive. Today we're looking at a story that honestly, it's pretty chilling. It involves an FBI raid gone terribly wrong.
Yeah, we're talking about Martin v. United States. It's a case about a family in Atlanta whose home was mistakenly raided by an FBI SWAT team.
And their fight afterwards, just trying to hold the government accountable, it really pulls back the curtain on some complex legal ideas.
Absolutely. It's a real deep dive into how government accountability is supposed to work. And sometimes how it gets tangled up.
So let's start with what actually happened, because the details are, well, they're stark. October 18th, 2017, right?
That's right, suburban Atlanta. An FBI SWAT team is gearing up to hit a house they suspect is linked to a gang. Address is 3741 Landau Lane.
But that's not where they went.
No. Instead, they ended up at 3756 Denville Trace. A completely different street, different house.
And why the mix-up? It seems like a pretty basic thing to get right.
Well, incredibly, they were apparently relying on a special agent's personal GPS device, not official equipment.
Wow. And did they check anything else? Street signs? House numbers?
Apparently not effectively. The agent later admitted, he actually threw that GPS away afterwards. So they missed the street sign, missed the number on the mailbox.
And just went in.
They breached the door, detonated a flashbang grenade inside, and confronted the people inside Curtrina Martin, Hilliard Toy-Clayat, and their young son.
Who were completely innocent, living their lives in the wrong house at the wrong time.
Exactly. They physically assaulted them before realizing, oh wait, wrong place.
Just terrifying.
Eh.
So naturally, the family sued.
They did. They sued the federal government, arguing two main things. Negligence for the botched planning, the bad intel, the failure to check the address.
Okay, the carelessness leading up to it.
Right. And then also for intentional torts, things like assault and battery for the actual physical force used during the raid itself.
And that brings us to the core of our deep dive today. Can you actually sue the federal government when something like this happens?
That's the million-dollar question. And the starting point is this concept called sovereign immunity. It's an old idea, really.
Like, you can't sue the king.
Pretty much. In modern terms, it means the federal government is generally immune from lawsuits, unless, and this is key, unless Congress explicitly says it's okay.
And Congress has said that sometimes.
Yes, with a law called the Federal Tort Claims Act, the FTCA. This is the law that waives that sovereign immunity for certain types of wrongs or torts committed by federal employees.
So the FTCA is basically the permission slip from Congress.
Exactly. It allows people to sue the government for harm caused by its employees, kind of like you could sue a private company if its driver caused an accident.
But I sense a but coming.
Oh, there's a big but. While the FTCA waives immunity, Congress also wrote in a whole list of exceptions, 13 of them, actually, where the government keeps its immunity. These exceptions sort of claw back that protection.
Okay, so it's not a blanket permission slip. There are loopholes.
Big ones. And for a case like the Martin families, two of these exceptions are absolutely crucial. We really need to unpack them.
Let's do it. What's the first major hurdle?
It's called the intentional tort exception, Section 2680 of the FTCA. This says the government generally isn't liable for certain intentional harms, like libel, slander, misrepresentation.
Okay, so if an agent intentionally lies, you can't sue the government for that lie itself under this part.
Generally no, but, and this is critical for the Martin case, there's a special clause within that exception.
Ah, the plot thickens.
It does. It's called the law enforcement proviso. It's like an exception to the exception.
Okay.
This proviso specifically says that the government can be sued for 6 specific intentional torts: assault, battery, false imprisonment, false arrest, abuse of process, malicious prosecution if they were committed by federal investigative or law enforcement officers.
So Congress specifically carved out a space for lawsuits
Bruh.
when law enforcement officers commit these kinds of intentional acts. Assault, battery, like what happened in the raid.
Precisely. This wasn't an accident. The proviso was added back in the 70s, largely in response to notorious incidents like the Collinsville raids, other wrong house raids, actually. Congress wanted to ensure there was accountability for this kind of misconduct.
So it seems like, for the assault and battery claims at least, the Martin family should have been able to get past that first hurdle because of the proviso.
You'd think so. It seems tailor-made for this situation. But then you run into the second major shield the government uses.
And this one sounds ominous. The discretionary function exception, the DFE.
Yeah, the DFE is often the toughest one, Section 2680. This says the government is immune from lawsuits based on its employees performing or failing to perform a discretionary function or duty.
Discretionary. Meaning they had a choice in how they acted.
Sort of, but it's more specific than that. The key is whether the choice involved considerations of public policy, social, economic, or political judgment.
Can you give an example?
Sure. The FBI deciding whether to conduct a raid, or what time of day to do it for maximum safety or effectiveness, those decisions likely involve weighing risks and benefits, policy considerations. The DFE protects those judgments from being second-guessed by a court.
Okay, that makes sense. You don't want judges deciding national security policy.
Right. But what about the agent executing that policy, like deciding which GPS to use or failing to double-check the address on the mailbox before breaking down the door? Is that a policy judgment?
Or is it just carelessness? Performing a routine task badly?
Exactly. That's the razor's edge. If it's just carelessness in carrying out a non-policy-based task, what courts might call a ministerial act, the government can be sued. If the action, even if negligent, is tied to a policy choice, the government is immune under the DFE.
That sounds like a really blurry line.
It is, and it's where courts spend a lot of time arguing. And interestingly, this is where the court handling the Martin case, initially the 11th Circuit Court of Appeals, went, well, way off script.
How so? Did they apply the DFE in a weird way?
They did, but it was part of a bigger, unique approach nobody else used. They made two really significant errors, according to the Supreme Court later.
Okay, error number one.
Their reading of that law enforcement proviso we talked about. Remember how it overrides the intentional tort exception for things like assault by cops?
Yeah.
The 11th Circuit decided that proviso was like a super trump card. They held that it didn't just override the intentional tort exception it sits inside of, but it overrode all FTCA exceptions, including the discretionary function exception.
Wait, so they thought if a law enforcement officer committed assault, the DFE just didn't apply at all? The government couldn't even raise that defense?
That was their unique view, yeah. No other federal circuit court saw it that way.
That seems really plaintiff-friendly, actually. If that were true, the Martin family's assault claims should have definitely gone forward, right? Bypassing the DFE entirely.
Well, that's what you'd think. And indeed, based on that logic, the 11th Circuit did say the intentional tort claims, assault, battery, could proceed past the DFE hurdle. But they also said the negligence claims, the bad planning part, were barred by the DFE, ruling the agent's prep work involved protected discretion.
Okay, so negligence claim out, intentional claims in, but then what?
This is where their second error comes in. Maybe because they realized their proviso interpretation made it too easy to sue for intentional torts, they kind of compensated by inventing a whole new defense for the government.
Inventing a defense. What was it?
They allowed the government to use the supremacy clause of the Constitution as a shield.
The supremacy clause. That's the one that says federal law trumps state law, right? How does that apply here?
Well, the 11th Circuit created this novel test. They said the government could escape liability, even for the intentional torts, if the federal officer's actions had some nexus with furthering federal policy and were reasonably compliant with federal law.
That sounds incredibly broad. Like, we were doing federal work, so state tort law doesn't apply to us.
Pretty much. It was a way to give the government back immunity even after their interpretation of the proviso seemed to take it away for intentional torts. And using this brand new supremacy clause defense,
They threw the case out.
they granted summary judgment to the government, dismissed the whole thing, negligence, and the intentional tort claims. The family's case was dead in the water based on these two unique 11th Circuit rulings.
Until the Supreme Court got involved.
Right. The family appealed, and the Supreme Court took the case, clearly seeing that the 11th Circuit was an outlier. And their decision was unanimous, 9-0.
Okay, so what did they say? How did they fix this?
They made two major holdings, directly correcting the 11th Circuit's errors. First, they addressed the scope of that law enforcement proviso.
The one the 11th Circuit said overrode everything.
Exactly. The Supreme Court said definitively no. The proviso only applies to the exception it's written into the intentional tort exception, Section 2680. It does not negate other exceptions, like the discretionary function exception, 2680A.
And their reasoning. Was it complicated?
Actually, pretty straightforward statutory interpretation. They pointed out the proviso is physically located within the subsection dealing with intentional torts. It's structurally part of that specific exception.
Like an ingredient listed under a specific recipe step only applies to that step.
That's a decent analogy. The court said provisos generally modify only the provision they're attached to. If Congress had wanted it to wipe out the DFE too, they would have likely written it differently, perhaps as a separate rule.
Okay, so the proviso is important, But it doesn't let law enforcement torts automatically bypass the DFE. The DFE still has to be considered.
Correct. Which means the Martin family's intentional tort claims weren't automatically doomed by the 11th Circuit's weird supremacy clause defense anymore. But they also couldn't just skip the DFE analysis.
Which brings us to the second big holding from the Supreme Court, that novel supremacy clause defense.
Gone. The Supreme Court unanimously rejected it. Flat out.
Why? What was wrong with the 11th Circuit's reasoning there?
The court said the 11th Circuit fundamentally misunderstood how the FTCA works with state law. The FTCA itself is the supreme federal law here. And what does it say?
That the government agrees to be sued?
Under the tort law of the place where the act occurred in this case, Georgia state law, just like a private individual would be.
So the FTCA itself already handles the interaction between federal immunity and state tort law. There's no conflict for the supremacy clause to resolve.
Precisely. If a private security company in Georgia couldn't legally break down the wrong door and assault the residents without facing liability under Georgia law, then the federal government, under the FTCA, faces the same potential liability. The FTCA adopts state law standards for liability.
So invoking the supremacy clause was just unnecessary and wrong.
Completely wrong. The court also swatted down the 11th Circuit's attempt to use a really old case, in re Neagle from 1890.
What was that about?
Neagle dealt with whether a federal marshal acting in the line of duty could be prosecuted under state criminal law. It was about immunity from state prosecution for official acts, not about the federal government's civil liability for damages under a statute like the FTCA, which explicitly adopts state tort law. Totally different contexts.
Okay, so the Supreme Court basically dismantled the entire unique framework the 11th Circuit had built.
Wiped the slate clean on those 2 points.
So what does this mean practically for the Martin family? Did they win? Do they get compensation now?
Not automatically. The Supreme Court's ruling vacated the 11th Circuit's judgment, meaning it's nullified, and sent the case back down, or remanded it.
Back to the 11th Circuit.
Yes, with instructions. The intentional tort claims, assault, battery, are alive again. They aren't barred by the intentional tort exception thanks to the proviso, and they can't be dismissed using that bogus supremacy clause defense. But now, those intentional tort claims, along with the original negligence claims, must face the discretionary function exception analysis correctly.
So right back to that blurry line.
Yeah.
Was the FBI's conduct, the planning failures, the raid execution itself protected policy discretion, or was it unprotected operational carelessness?
That is now the central question the 11th Circuit has to decide without using its previous incorrect assumptions about the proviso or the supremacy clause.
And the Supreme Court didn't give him any hints on how to decide that.
Not directly on the facts of this case. They explicitly acknowledged how difficult applying the DFE can be, noting it's a major point of contention in lower courts. They basically said, okay, 11th Circuit, here are the right rules. Now you figure out how they apply to this raid.
So the fight comes down to whether things like, say, failing to verify an address before a dynamic entry is considered a policy choice, or just screwing up a basic task.
Exactly. Is it a judgment call based on considerations of public policy, which is the standard from a key Supreme Court case called Gobert? Or is it more like, say, a federal bank regulator driving negligently on the way to an audit?
Driving carelessly isn't policy, right? Even if they're on the job.
Right. That's usually considered operational negligence, not protected policy discretion. The government would likely be liable for the car accident. So the 11th Circuit has to analyze the specific actions of the agents here, the GPS used, the address confirmation, the execution tactics, and decide which side of that line they fall on.
So wrapping this up, what are the big takeaways from this whole legal saga?
Well, 2 main things. First, the Supreme Court clarified the rules of the road for suing the government under the FTCA. That law enforcement proviso is a specific tool against intentional misconduct by officers, but it's not a magic key that unlocks every door. Other defenses, like the DFE, still apply.
And second,
and maybe more fundamentally, the court shut down the idea that the government can just invent new constitutional defenses out of thin air, like that supremacy clause argument, to avoid the liability Congress explicitly allowed in the FTCA. The government has to play by the rules Congress set.
Which means victims of federal misconduct, like this family subjected to a terrifying wronghouse raid, at least get their proper day in court under the actual law.
Yes, they get the chance to make their case under the correct legal standard, which is usually state tort law. But, and this is the lingering question,
The DFE.
the DFE. The entire possibility of accountability now rests on this incredibly difficult distinction courts have to make. Where does protected policy judgment end and simple carelessness begin, especially in the chaotic context of a SWAT raid?
Can a court truly parse that difference after the fact? That seems like the challenge left unresolved.
It absolutely is. And how the courts continue to draw that line in cases like this will ultimately determine whether families like the Martins can find real justice when government actions go tragically wrong.
A really important clarification of the law, but the hardest questions might still remain. Thanks for breaking that down for us.
Glad to. It's a critical area of law.
And thank you for joining us for this deep dive.